In the area of work-based immigration, the laws haven't changed, but there have been actions at the executive level that make it more difficult for U.S. businesses who have international workers. Last year, the President signed the Buy American, Hire American Executive Order, also known as BAHA. It's a call to reform and to add restrictions to the H-1B visa program and other employment-based immigration programs. The executive order did not eliminate the H-1B program or other employment-based visas or change any of the regulations, but it has influenced USCIS decision-making in adjudicating those cases. Among the things USCIS is doing or considering doing as a result of BAHA include plans to end special work permits, more challenges and requests for more evidence by USCIS, more policies that make it more difficult for companies to prove their employees' H-1B status, more surprise visits by USCIS's fraud team. All these actions are at the administrative level and do not require the involvement of Congress. We believe BAHA has led to an increased examination and unlawful denials of all work visa categories. This environment has made it tougher on U.S. businesses who have an international workforce. That is why the recently announced update to NAFTA, the U.S.-Mexico-Canada Agreement, USMCA, is worthy of attention. NAFTA was our free trade agreement with Mexico. It's designed to make it easier for commerce to occur between our countries. Among its features is a provision which opens up opportunities for lists of professional workers to be eligible for work visas called a TN visa. Those visas allow Canadian and Mexican nationals to work in the U.S. for an American or foreign company for a renewable term of 3 years. USMCA is a purported overhaul of NAFTA, which was announced in the late summer of 2018. Though there seems to have been some updates to the current agreement, the work visa provisions of NAFTA seem to have avoided any changes. TN visas made it onto the new agreement, and the list of qualifying professions remains the same. But as we have seen with H-1Bs, procedural and administrative changes can have a very big impact. Currently, Canadians could just present themselves at a port of entry, show their qualifications, and gain admission to the U.S. As restrictions are increasing, we don't know whether or not that will continue. The new agreement potentially opens up the TN program to renewed scrutiny and increased restrictions. For now, there are no changes, but as the agreement moves through Congress for approval, and as the Department of Homeland Security has the opportunity to determine how its provisions will be implemented, it's important to stay informed of any future developments. Despite this environment, immigration to the U.S. and international business in the U.S. is still happening. However, it's more important than ever to carefully comply with the rules. Omissions and innocent mistakes, which before were easier to fix, now can lead to negative consequences, more negative consequences than ever before. Working with a competent immigration attorney is the key to navigating this environment, and that's what you'll find at Scott, Pollock & Associates.